And we're live.
All right, welcome back. This is the House Transportation Committee. We're back from our break. We're gonna be delving back into the miscellaneous DMV bill S 326. And I think this was, my understanding, but this was a section that was presented, in the, this piece on total abstinence was presented to the, Senate down the Transportation Committee, and it didn't make it over. So I'm not sure how far along the process it got. But we want to give it its due diligence and have that testimony presented to us. And then we can make a determination whether or not if we want to move forward. But we're going to have a presentation on that. We have Dan, if you want to, over there. If you want to join us, and for the record, you could just state your name and what department of DMV you're with, and you can take it away.
Morning. My name's Dan Merchant, and I'm a lieutenant with the Enforcement and Safety Division within the Investigations Unit, which oversees the total abstinence program. Let me see here if we can. Did I get it to work? Yeah, we do. Oh, how about that? So I put together a brief presentation on the total abstinence program, and have also put together the proposed changes that just briefly mentioned. So the total abstinence program is designed for people who have received a life suspension after multiple DUI convictions. That's 3 or more. An acceptance into the program allows them to no longer operate a motor vehicle without an interlock device, and they receive a conditional reinstatement of their driving privileges. So in order to qualify, yes, sir.
I was reading this ahead of time.
Okay.
That sentence, I was confused. It says allows them to no longer operate with an interlock device. So it should be without, I guess.
I make an error there.
That's okay. Yeah.
Third line.
To no longer operate with an interlock device.
Okay.
Yeah. So
So it should be they can operate without an interlock.
Correct.
device. Okay, great. Thanks.
So to qualify, I'll just say TAP for total abstinence program. So to qualify for TAP, you have to have at least 3 years of being abstinent from alcohol, beverages, illegal drugs, or misuse of a prescription regulated drug. Even some beers and wine labeled non-alcoholic typically contain alcohol and also may not be consumed under total abstinence. Applicants must have installed and utilized an ignition interlock system in their vehicle for 3 full years prior to application to TAP. So that's one of the proposed changes. Is the current language doesn't say the 3 years immediately preceding application. So for instance, there's a gentleman who has applied who has several years of interlock records, but they're from 5 years ago, where he had 3 years of interlock. However, he currently has a suspended license and has applied to TAP. And if he gets reinstated through TAP, then he would have his driving privilege reinstated through TAP. However, to do our due diligence and be somewhat confident in that this person has been, abstinent, we don't have those interlock records, those 3 years immediately preceding the application. We have historical data, which is not helpful. They also must complete an impaired driver rehabilitation program. And then they also have to successfully complete treatment with a licensed alcohol drug counselor.
Was there an incident that triggered this, or was it just more of us dotting our i's and crossing our t's and saying,
We've had a few applications, and there was one recently that came to light, and by statute, technically what's in there, we have to take that application and investigate it. So not having that 3 years prior is not conducive to conducting a
So
thorough.
there was an incident that sort of triggered that for us to look.
Correct.
At. It's not like speculative. Okay.
Correct.
Representative Burke.
Yeah, so I'm just starting to read this. This means that they they have the interlock for 3 years. And if they're successful in all aspects of the program, they can get rid of the interlock device.
If they meet all the requirements of TAP, like, well, I'll get into the various.
Yeah.
Requirements.
Just wanted to be clear.
Yeah, I was just wondering if you could, and maybe you'll get to it, like, a scenario where, okay, you know, you don't have an interlock device, you don't, and then, you know, you get arrested and convicted of, driving impaired the first time, sort of what happens, then the second time, when does the interlock device kick in and to lead to this potential TAP program? Can you just give us a scenario of what that might look like for somebody?
So there's there are a bunch of different scenarios that I can't even begin to go into all of those for you. Usually, I will say usually based on what I've been told by the folks in our driver control unit, because they monitor the interlock program, is that it's usually after your second, but there are instances after the first where you may be required to get an interlock, and it could be something from the court, could be something from probation, it could be a few different things based on my understanding.
So at some point, first or second offense, convicted offense, you know, you might be offered the opportunity to get an interlock device.
Correct, but they can eventually reapply and be eligible if they complete certain requirements that are in statute related to the DUIs. However, after this is designed for people that have obtained that lifetime suspension, so people that have the 3 or more. So these are the folks that have had.
They had the interlock device and they failed again for whatever reason. They you know, lost that.
Maybe not. I mean, it could be somebody who's, you know, obtained several convictions for DUI, and based on those convictions, they're suspended for life. So if they want to try and get to a conditional reinstatement license without interlock, then this is the only option for that. Otherwise, I'll get into it. Most states require folks, if they have 3 or more, to be on interlock for life.
Representative Vogt?
That's a breathalyzer, that interlock system. Does the driver pay for that, and what's the cost?
There is, yes, the driver has to pay for that. I do not know all the costs. Different the state has contracts with a few different providers. Once again, the driver control deals with that. I should have asked them to be here to help with this. But they manage that, and there are certain costs that, you know, folks have to pay to have that, and it requires regular service. There is maintenance of it. They have to go in at certain times. If they don't, those can be a violation of their interlock agreement that they have with the state. So driver control gets those interlock agreements that they have with folks. And if the manufacturer from the interlock program will end up like basically messaging them saying, hey, this person missed their service, or there was this, or, you know, there's a variety of ways that comes up.
Thanks.
Representative White?
Yeah, thank you. So I'm going along with Representative Couch's question. So just trying to get big picture. So I've gotten 3 DUIs. I've lost all my privileges. Do I have to? So when does? Because I assume once you lose all your privileges, you are not driving for a while or forever.
So if you get suspended for life, you can apply to the restricted driver's license program, which is the interlock program.
Okay, how long, once you've been restricted for life, how long are you not doing any kind of driving? How long do you have to wait to apply to the interlock program?
You have to look in statute, see what that says.
Okay,
I don't know that off the top of my head.
okay, but I'm
No,
assuming
we
there's a
changed that.
period of time.
Well, no, you can almost get it in the first DUI. So you don't have, I mean, unless I'm wrong, but I think you can get it right. We changed that, I don't know. Years ago, you could get it.
Okay, so I
you
get, so I
lose
get
any
one
drive.
DUI
Hmm.
and I get convicted, whatever, and then,
I suspect it's right off because we have folks that
okay,
apply to interlock that their date of abstinence is their last DUI arrest. So
Yeah.
I,
As soon as they sober up.
okay, so they're drinking, they need to drive, so the only way for them to drive is to get this interlock program.
correct.
And, okay, and so they're using the interlock program, and then once they've done that for 3 years, then
They can apply to total abstinence.
then they can, okay, that's what I needed.
Yeah.
Thank you.
Yeah.
Representative Burke.
Are there some people who just want to use the interlock program for the rest of their lives and just be able to drink? I just wondered, like.
It's a very honest question, and I'm not going to answer for somebody else, but
I mean,
I think it's within the realm of
They
possibility.
wouldn't necessarily want to get the, you know, the.
Into this program.
That they just want to drive
Correct.
and they're gonna maybe have a drink now and then, and they have the interlock program so that it prevents them from driving after they've been drinking.
If they're using that specific car, yes.
So,
They're using their car that they have registered
Yeah.
with interlock
Yeah,
and that they have it installed in, but could someone get access to another car and still drive? Absolutely.
yeah, right.
But for their own particular
Yeah,
car.
I just wondered, there might be just some people who just can't stop. And they need to drive and they're doing it responsibly because they are making sure that they don't drive. with an interlock.
Absolutely possible.
Yeah.
So currently, there are a little over 1,000 people reinstated in TAP here in the state of Vermont. And so what happens is they submit an application packet to DMV Enforcement and Safety, review all the necessary documents are in there. And then once all the necessary documents have been presented to DMV of what's required, it gets assigned to an inspector. The inspector reviews the application packet and then starts going through their interlock records prior to conducting a home visit. So we conduct an unannounced home visit and we review their declaration that they've made regarding their total abstinence with them during the interview. We obtain applicable medical releases from them. And we conduct a cursory search of their residence and we obtain a urine sample from them during that home visit. That urine sample is later delivered to the forensic laboratory and it's sent out for analysis. You look in their fridge, see if there's, beer, alcohol, in the cupboards. We serve those to healthcare providers, as I'm sure most of you go into a doctor's visit. What do they ask you during a doctor's visit? Do you use alcohol? How much? How often? Do you use drugs? How often? So we obtain those hospital records. We review all of those hospital records as part of the total abstinence investigation. The inspector will do all of this. And we've got to be able to, when we also do this home visit, we speak with them. Are you serious about your abstinence? You get one shot at this, one bite at the apple. And this is what can happen because it's in the declaration that they can, have their lifetime reinstatement reimposed if they were to violate total abstinence. And so we've got to say with some level of confidence that the applicant can maintain that abstinence indefinitely based on our interview with them and our investigation. You can check local stores, to see if they've been in buying alcohol. They have to provide letters of reference to check with those folks doing the, and speak with them to see what their history is. And then ultimately, we complete an investigative report and we send that to the AOT hearings officer, at which point they will then go before the AOT hearing officer if we recommend them for total abstinence. And they will testify on the record and they will then also recognize that on the record that what the requirements are for total abstinence. And they're told if they were to use alcohol or drugs or abuse a prescription outside the prescribing label, that could result in their life suspension being reinstated. Also, all of these folks that are in the total abstinence program are entered into what's called the subscription alert database. So that way, if law enforcement or EMS ends up dealing with these folks, it goes into if their name is entered in, we get an alert. So like when I sign on in the morning, I get an email, usually at least 1 to 3 per day, of folks that have had some type of interaction with law enforcement, whether it's just traffic stop for speeding or, an overdose at their residence. It can be a variety of different things. And if there ends up being something within those subscription, we look into that. We will then make an unannounced visit to have, a conversation with these folks. And we will, speak with them about their abstinence, how things are going. And, if there's evidence that they are obviously violating that, they're presented with that evidence. And, we ask to speak with them. We ask them for a urine sample or, a breath sample based on what we're seeing or what they're telling us. And folks will ask us, and that's also part of the proposed language, is do I have to? Currently, they do not have to. This is a voluntary program and they can deny that. So for instance, just one gentleman, had empty bottles of whiskey out on his porch, clearly visible in his bottle bin, and asked him for urinalysis. He's like, do I have to? I'm like, technically no. However, help us with our investigation. Absolutely no. I had one this past weekend where we've had complaints about this gentleman abusing narcotics and an apparent heroin overdose. Gentleman died on this person's floor. That's still an active investigation. So there are a variety of different things that happen that we get these alerts about. Yeah.
On that point, though, I mean, this isn't like innocent until proven guilty. This is a program. I mean, why would you even need the urine sample if you saw a bottle there? Isn't it within your discretion saying you failed, you're going back on lifetime?
Just because there's an empty bottle, he said he had guests over that were drinking at his residence.
No. What I'm saying, though, this isn't a court of law. I mean, in my mind, it's different. I mean,
Yeah.
you
For AOT, yes.
pray prove to you, but if you see a bottle, you can't make that.
I've got to prove that they've been consuming in violation of that. And if we can't prove that, then there's no way to revoke them again. I mean, that person's now, if they're back to drinking again, they're now a liability again because they don't have that safeguard in place where they had before with the interlock. So that was one of the things, was having something in there that's similar to the DUI language. Like if a person refuses with a reasonable request for a sample, that they would then have their lifetime, reinstatement. I mean, this isn't just on a whim. These are times where we go out and it's because of the contact that they've had with local law enforcement or state police or whoever it is. And, we go out there and do that investigation.
So I know what you're saying, though, but it's just in my mind, it's like when somebody's on probation, they lose a lot of the rights. They're in this program. It's weird that you would have to prove, yeah.
Sorry.
You're sure.
You're not getting an argument from me on that,
Yeah,
sir.
that's just, I don't know. Pick that up.
Yes, sir.
And maybe you're getting to it. So in the case where they refuse to provide a urine sample, is that automatically,
I can't do a thing to them. That's them.
it's their right?
It's their right to not provide that sample. I can't compel them to do that. If there was a criminal element, I mean, could I get a warrant and ask for a urine sample?
Car accident, then you could.
If there was a crash, well, I'd be asking for blood in that scenario. I wouldn't be asking for urine. Urinalysis is the least invasive, pee in the bottle and we bring that to the lab, they send it off and we get the results back. So this program is actually unique to the United States. I go to these various conferences with AMVA, like the American Association of Motor Vehicle Administrators, and they talk about the various restriction codes. So for instance, when you have an interlock device in your vehicle, there is a T restriction on your license. And that T restriction is known throughout various, motor vehicle records as well as motor vehicle agencies. Vermont with the total absence program with TAP, it's an F restriction. No one else has that. So for instance, say I live down in White River, I'm a Vermont resident, and then maybe I move across the river over to New Hampshire. If I go over to New Hampshire and I apply for a license, that F restriction is not going to be recognized by the state of New Hampshire. So they get a clean license with no restrictions technically they're still in our total absence program. So if they were to, get dealt with in Vermont, get arrested for DUI again, that would, violate them in the program. But I just wanted to point that out. Like, Utah actually just did this new thing where they've even put it on their credential where it says no alcohol sale to folks that are, what they deem extreme DUIs, offenders. Just wanted to hit on that. So these are the statistics for the last 5 years for basically the investigations that we've conducted. So you see the approvals, denials, and revocations. The revocations are exactly what I was talking about. Like we get a report, we go out, we investigate, and show that they have been violating terms of the program. The denials are folks who applied to us and at some portion of the investigative process, we determined that they have not been abstinent as claimed. So when we determine that, we deny them. And the statute's not specific. It says once you're in total abstinence, you have, that one chance. It doesn't speak to if you apply to total abstinence. So for instance, we have a gentleman right now, this is his third time applying to total abstinence. We've done 2 other investigations on this gentleman where we proved that he had not been abstinent as claimed. So that's just one that we're dealing with right now. I just assigned it a couple of weeks ago to one of our field inspectors. This is his third time applying. So that was what that other change was proposed, was to deal with folks like that, where if you're serious about this and you're serious about your abstinence, that one time should include your application process. And the revocations do not include when a participant is arrested and charged for DUI, because the civil suspension is sent to our driver control unit, and the driver control unit suspends them as a result of that latest DUI arrest. In some instances, when it's for, say, narcotics and they're waiting on the blood, that civil suspension isn't immediately submitted. So we still go out and we will do an investigation in those instances as well. These were the various, like I mentioned, so individuals that have submitted a proof of ignition interlock use for 3 years, but not immediately preceding the application. It's tough because it provides no evidence of how this individual is doing with the IID, the ignition interlock device, and whether they have any issues within those last 3 years. And then the other, like I said, the other proposed language was that would allow for, an officer on, based on reasonable grounds to believe that the person's in violation of TAP, to make that request and to have some cooperation with that request. Currently, there is no requirement for them to cooperate. And then same thing goes, what I just mentioned with, someone that applies to the program and continues to apply to the program. They can do it, and it doesn't say that anywhere that that's their one bite at the apple, so to speak.
Representative Hodge.
So without the rest of the language that goes with this, like B3 says, individuals have submitted proof of ignition interlock use for 3 years, but not immediately before they've applied.
Correct. It doesn't say immediately preceding. Jordan, do you have that form that you can pop up with the language that?
So they have 3 years worth of data, but then a year they didn't use it or whatever. They didn't need it anymore. I don't know. And now they've applied. Are you saying, hey, if you have the 3 years, that's good? Or we're saying, no, it has to be only 3 years in front of
Based on
the
what's
application.
based on what's currently in statute, we have to accept that application and investigate it.
Okay, so today, if you have 3 years, then a year of no use, no record, no use, and they apply, you got to go through the application process.
I mean, you can still go, like, they're going to apply, like, what I'm trying to get at is it's tough for us to have some degree of confidence that this person's been abstinent as claimed when the 3 years leading up to their application, we have no interlock data to go on. I mean, yes, there are other avenues that we're going to investigate. We're going to go and talk with their associates, their references, and, same thing. We're still going to do a home visit. We're still going to do all that. But not having that data for the 3 years prior to the application, it just, quite frankly, doesn't make a whole lot of sense.
And so what you're trying to do, change it that it has to be 3 years.
Immediately preceding your application. So the 3 years preceding your application. So if, say I've been suspended for 12 years and I drove with an interlock for 8 of those 12 years, and then I really, can't afford to pay that right now, or, I can't do this right now, like a variety of different reasons. And I'm just going to drive around suspended and hope I don't get caught. Then they can apply. However, they are currently suspended. But if they were to be accepted in this program, they would then be reinstated into TAP. So which also seems counterproductive is that somebody with a not a valid license can then apply to a program to get a valid license.
So I'm confused about the proposed language changes because I feel like this is saying individuals have submitted proof of ignition interlock use for 3 years, not immediately preceding application. And I thought you were suggesting that you wanted to say immediately preceding application.
Let me see if I can get out of this. How do I not?
I think he's just pointing out there that that's the issue. That's not what he wants. I think this is where he's highlighting.
Yeah, we've sent over the languages. I'm trying to see if I can, how do I unshare this screen?
You have a, well,
Looks like you have, because we don't see it.
but that's still his computer, just not.
I got it right there. Thank you. Get there. See if I can get into this.
Basically, what you want is you want to have an application and then 3 years of interlock information before you issue a reinstatement. That's what you want.
We want 3 years preceding that application.
Yeah.
Stop with proceeding.
Yeah,
Say you had your application, you want 3 years after that of interlock information before you would reinstate.
Correct.
Okay. Thank you.
So let me see if I can get this. Sense to me. I'm gonna share this now. Now I'm gonna try and get this back up. I am not very good with technology, so do my best here. Share this again. Share. This was the language here that we screened. Oops. These were the various languages that are in there, and then the highlighted sections that we wanted to have added. So the immediately preceding the application, and then this shall include providing a sample of your analysis, examination, breath sample, if requested by any law enforcement officer or motor vehicle inspector at any time, if reasonable grounds exist that the participant is violating the terms of the total absence program. So for instance, in their sworn declaration, when they apply, it says that they have to, comply during the initial investigation period, but there's nothing after that. They're never told that during their AOT hearing. There's no cooperation once they're accepted into the program, which is a voluntary program. It's called total abstinence, saying I'm making this promise, I'm going to be abstinent. And then, so that was the language change there. And then same thing, this would in B4 here, where it talks about that request and what would be imposed if they didn't cooperate with that request, if that were granted.
This seems so weird to me. Like if you get pulled over for like a DUI and you refuse to cooperate, do the field test and you're found guilty. Weird till you see a bottle and you don't have the authority to kick them out of the program. But your lawyer could have looked at this, and that's, you're standing by that
Yes.
assertion that you have no authority to deem them.
I mean, it's a preponderance of evidence. I mean,
Yeah.
so say I've got the whiskey bottles, then I've got,
Yeah.
that same guy, the neighbor said he was stumbling drunk when he'd come downstairs. He was belligerently yelling at his neighbors. And, you know, I've got all these things and I present all of that. Without that definitive evidence, we did not revoke, that gentleman did not get revoked from the program. Oh.
So the first instance of proposed language is like make the 3 years prior, immediately prior to applying for the program.
Yeah.
The second one is in the same way when you apply, you have to give a sample. If there's reasonable grounds during the program you're involved, you have to provide that sample.
After they've been accepted into the program.
Yes.
So yes, during the initial period where they've applied, that is in the declaration in the paperwork that they have to provide that sample. If they don't, then we stop doing the investigation. But once they're accepted, there's currently no mechanism.
Specifically required to, so
Correct.
the language that you're adding, the second instance of language change is that, hey, when you're enrolled in the program and, you know, through an investigation, you're asked to provide a sample, you have to do that. Otherwise, you're out of the program.
Correct.
And then what's the third one?
It's the third one is regarding whether or not that attempt to apply and the denial that comes from that is the one chance that you get to apply to the program. So right now, like I said, like we've got this one gentleman we're currently dealing with. We've denied him 2 previous times because we determined he had still not stopped drinking. And he just keeps reapplying. So every, say, a year and a half back from his, you know, from our investigation, we determined he drank at that point. From that date forward, he can have a new claim of abstinence. So for instance, actually, we use this other one. We had a gentleman who applied and it was like 2.5 years that he had used. It was on his interlock records. We confronted him with it. Finally, you know, he admitted, yep. However, it was not too long after COVID, there was a backlog of these because we weren't going into people's houses at the time. And by the time this all resolved, by the time he had the hearing, it was after he contested it, it was after 3 years. So the hearing officer ordered us to do a new investigation from that vague period of time when we had stopped the investigation until he appeared for his hearing to ensure that he had been abstinent during, I think it was like 7 months. And once that was determined, based on the previous investigation where it had been determined like back that length of time, they let him into the program.
So I'm a little confused. So what you're saying here,
Is the one, your one chance, like when you're in the program and we determine that you have violated the terms of abstinence, you're out and you don't get a chance to reapply.
at one time, only,
Correct.
one strike.
One strike, because these folks have, you know, 3 or more convictions. In some instances, there's people with 7 convictions. So 3 or more convictions, and now they can currently just keep reapplying.
So as part of this, the reason for making it a little stricter or requiring, you know, real abstinence, is it because the previous statistics we saw that it didn't look like it was a very successful program in that, you know, you allow X amount of people come in and almost the same amount get kicked out.
Yeah, and I mean, up until 2023, the DMV issued letters to everyone in the program. Depending on when you were reinstated in TAP, previously you could still continue to drink, just not drive. So like back in the late 90s, as long as you weren't over an O2, you could still drink.
Qualified for the TAP program.
Once you were accepted in the program, it wasn't a violation unless you were driving a vehicle. So for instance, we went and dealt with this one gentleman who was in the program. We had gotten a complaint about his drinking. State police responded to his residence for domestic assault based on the body cam footage. Clearly intoxicated, inebriated, incapacitated. And we go and speak with him after he gets home from work. We asked for a urine sample. He gives us a voluntary urine sample. Ethanol was in that urine sample. However, he didn't blow any numbers. So he still had some trace amount of alcohol in his system. He's still in the program. That wasn't determined to be a violation.
So now,
Now, yes, it would be. And so that in 2023, we sent letters out to everyone in the program saying total abstinence is now total abstinence because the law changed.
Of these 1,000 people that have been reinstated in this program throughout the years, do you have an indication of how many had more than one bite at the apple?
In applying,
Well, the change you're saying is that if you screw up, you're all right, but is there examples where people had one bite at the apple and then came back and really made it work for them? I'm just wondering what this proposed change that you're asking us to consider, what effect would that potentially have on those thousands of people that have been reinstated?
yeah.
Or did they get it through the first time?
So I've been here at DMV for 6.5 years
Yeah.
and dealing with the total abstinence program. And I can think of a handful that, have applied who had been denied previously. I don't think any of them have currently violated.
No, they're just curious. Just
Yeah.
trying to get a-
I'm trying to think back of who those folks were, and I don't think currently any of them have violated.
I think this, now, obviously, these people have addictive personalities. Is there any social services that are available? I know that lots of available, but is there anything that this system or that your interaction with them addresses the social issues where you might support their abstinence?
As part of when they apply to us, they have had to have that, work with a licensed alcohol and drug counselor.
Oh, okay, all right.
That's part of the requirement to come in. So
Okay.
they have gone
Okay.
through counseling, they've gone through IDRP. Yeah, they've had to do that at least that other program at least 3 times as well regarding that. But yeah, absolutely. Prior to being at DMV, I was a Burlington police officer for a little over 20 years. And during that time, a lot of my work was dealing with narcotics. So, will someone replace one thing with another? Absolutely. And do folks have addictive personalities? Absolutely. Does not discriminate.
Any other questions?
So if you get in the TAP program, and then you fail, can you go back and get the interlock device?
Yes, yes, you can. So that's the only option. But, we just dealt with one gentleman who was violating the interlock because he's been abusing cocaine. But unfortunately, he can go back and get on the interlock.
Yeah.
But that interlock's not gonna account for.
Other drug use.
Correct.
That's alcohol.
Correct.
Representative Perks?
yeah, I was just reading that, if somebody goes out of state, I don't understand this. If somebody moves out of state and obtains a license in a different state, the F restriction is not recognized. And therefore the TAP participant can obtain a credential in a different state without any restrictions.
Yeah, it's because, so the interlock restriction is recognized nationwide.
Huh.
This program is unique to Vermont, so it's not recognized. So that F code doesn't mean anything to any person in any other state. So for instance, when we sent those letters out, we ended up getting some of those letters returned to us. One gentleman is out in Illinois and he now has a school bus endorsement. And this gentleman that got dealt with this weekend down in Southern Vermont, he has a CDL clean license over in New Hampshire, who is technically still in the total abstinence program, but he went to that other state. They didn't recognize that restriction. They don't recognize it because it's unique. So
But
they have a clean license.
he's clear to drive
He's clear to drive
because he's participated in the total absence program. Or
because he's been given that restriction. So that restriction code here in Vermont would not allow him to do certain things. But if they go to another state they don't have total abstinence, they have the interlock program, because folks got to stay on the
So he
interlock.
has to do the interlock.
No.
No.
He's in total absence. He's got a clean license as far as they're concerned.
All right, fascinating stuff. Any other questions? If not, obviously we'll deliberate this when our chair gets back and see what direction that we want to go with this. But we appreciate your testimony and your presentation. It gives us obviously a little better idea of what this program is, for sure.
Thank you very much.
All right,
Thank you.
And with that,